The topic for today is divorce. It has two parts. One is divorce by husband and other is a judicial divorce. So far as the ways of divorce are concerned, a husband may divorce his wife without intervention of the court, and the marriage may be dissolved by mutual consent of the parties without intervention of the court. And the second way is by judicial divorce. So we have three types of ways of divorce. Number one is by the husband without intervention of the court, and other is by mutual consent of the parties, even without intervention of the court, and the third one is by the judicial pronouncement. So we have divided this chapter into two parts. One is divorce by the husband, and the other is the divorce through a judicial process. So far as the divorce through judicial process is concerned, it is not a topic for today. We are only discussing the ways of the divorce and how it is exercised by the husband. So a husband has unfettered powers to divorce his wife. He may divorce his wife without assigning any reason. He may divorce his wife at any time he likes. This is the reason why this is called talaq. Talaq is by husband, and a husband under Hanfi law of divorce has unfettered powers to divorce his wife without assigning any reason. Nobody can ask as to why you have divorced your wife. He will say, "It is my sweet will." So the divorce by the husband is dependent upon the sweet will of husband. In the legal terms, we can say that a husband has unfettered powers to divorce his wife. For the purpose of divorcing the wife, a husband should be of sound mind and not a minor. A minor husband cannot dissolve the contract because, as we saw in the earlier lecture, that marriage is a civil contract. So all the ingredients for contract are fulfilled when the nikah is solemnized. So marriage is solemnized according to the contract. So this is called a civil contract. When a contract may be entered into by a person of sound mind and who has attained the majority, the same principle will apply for the dissolution of the said. So the contract is rescinded by a person of a sound mind. Similarly, a contract is rescinded by a person who has attained majority. So the person who has attained majority and a person who is of sound mind may divorce his wife without assigning any reason. So there are certain examples of a contingent divorce. A divorce may be pronounced so as to take effect on the happening of certain future event. For example, if a man and a woman enter into a marriage contract with a condition that the wife shall be entitled to divorce, or the marriage shall be dissolved if the husband does not pay maintenance to the wife, or it is a condition that the husband shall arrange for a house for the wife, and if he does not arrange, the marriage shall stand dissolved. And in this eventuality, if the husband fails to maintain, or if the husband fails to provide the lodging for her as required by the contract, then the contingent contract requires that the marriage shall be dissolved. So in the legal terminology, we may say that the contingent divorce is a valid divorce. A divorce may be pronounced so as to take effect on the happening of future event. As I have given you the example, that at the time of contract, when the parties enter into a contract, that this arrangement shall be made by a husband. And if he fails to make those arrangements, the marriage shall be dissolved and there shall be a divorce. So on the happening of that event, the marriage shall be deemed to have been dissolved. I have given, for there are certain things that a wife may say that I don't have the knowledge of the divorce. So the knowledge is immaterial. If a husband divorces his wife and he conveys it to the wife, well and good. Even if he does not convey it and he declares the talaq in accordance with the injunction of Hanfi law of divorce, the marriage is dissolved and the talaq is valid and effective. So we may say that the knowledge of the wife of the divorce is immaterial. It may be oral and it may be in writing. Writing itself is not a divorce. It is the oral words pronounced by the husband are the declaration of divorce. A marriage is dissolved, a talaq is effected when the husband pronounces talaq orally. First he will pronounce it orally and then he will reduce it into writing. So we may safely say that the writing of talaq itself is not a talaq, but it is an evidence of the talaq which husband has pronounced. Sometimes it happens that the husband, instead of declaring divorce, writes the same on the paper. So it is the intention of the maker of divorce. It is the intention of the husband who declares the pronouncement, and that intention may be gathered from the words of talaqnama, even if he does not declare orally. Sometimes it happens that divorce deed is written by him, and in that divorce deed it is written, I divorce thee thrice. So that writing becomes talaq, and that talaqnama itself is indicator of talaq. So it may be said that talaq is oral and the writing is evidence of the oral divorce. If there is a writing, it declares that the husband has divorced the wife. So the oral or writing, both are the modes of divorcing a wife. So far as the different modes of talaq are concerned, these modes are recognized by Hanfi law of divorce. Number one is talaq-e-ahsan, number two is talaq-e-hasan, and number three is talaq-e-biddat. These are the three modes of talaq which have been prescribed by the Hanfi jurists. Single pronouncement in a single Tuhr and abstention from intercourse during the period of Iddah, that is called talaq-e-ahsan. And in the simplest form, we may say that talaq-e-ahsan is a single pronouncement. It is a single pronouncement in one Tuhr and abstention from entering into sexual intercourse in this duration. That is called talaq-e-ahsan. The second mode is talaq-e-hasan. In that mode, there are three pronouncements separately. One single pronouncement at one time during one Tuhr. So we may say that this consists of three pronouncements. All three pronouncements are made separately, successively. One divorce in one Tuhr, second in the second Tuhr, and the third is in the third Tuhr. So all these three pronouncements are separately made in every Tuhr. And when the third pronouncement is made, the talaq becomes effective, in spite of, apart from the fact that iddah has been completed or not. That is immaterial. So talaq-e-ahsan and talaq-e-hasan. These are the two main modes of divorce which are recognized by Hanfi jurism. And there is another mode of talaq, and that is called talaq-e-biddat. This mode of divorce is usually seen in the subcontinent. In the subcontinent of Indo-Pak, there are several examples when one man divorces his wife at one and the same time in a single pronouncement and pronouncing all the divorces in one and the same time. He says, I divorce you thrice. But when he says that I divorce you thrice, it is talaq-e-biddat and effective at the one and the same time. Sometimes he may say, a Hanfi Muslim may say, I divorce thy thrice. Then second time, I divorce thy thrice. I divorce thy thrice. So when a Hanfi Muslim says like this, the talaq becomes talaq-e-biddat and effective at the very moment. So this way of talaq is called talaq-e-biddat. So far as this talaq is concerned, it is known as bidai form of talaq because sometimes it happens that a person divorces his wife without his will in order to pacify the passions of others. Suppose a father says to his son, divorce your wife. And the moment he hears the words from the mouth of his father, he at once diverts his attention towards his wife and says, I divorce you thrice. It is a valid divorce. In spite of the fact that he was not willing to do this, but he did at the instance of his father, or in order to please any other person. So far as this talaq is concerned, this is effective. And there can be no excuse to it that I did it on behalf of other, I did it on account of other, I did it to please the others, I did it at the instance of my father, I did it at the instance of my mother. So he cannot give these examples and cannot abstain from the consequences of the divorce. The divorce is effective. So the talaq-e-biddat is a talaq which becomes irrevocable at the time when the three pronouncements are made, even at the instance of any other body, even if to please his parents or to any other person. So far as this talaq is concerned, this talaq is irrevocable. It becomes irrevocable in the a talaq in Ahsan mode is the talaq which requires performance of period of Iddah. And so far as the Ahsan mode is concerned, third divorce, third pronouncement makes the marriage dissolved irrespective of Iddah period. So far as the talaq in badai mode is concerned, it becomes irrevocable immediately it is pronounced irrespective of Iddah. Whenever it is pronounced, it becomes effective. So that there is a difference between talaq-e-ahsan, hasan and talaq-e-biddat. Talaq-e-ahsan requires 3 menstruation periods, 3 tuhurs, while the talaq-e-biddat does not require this kind of obligation. This is what which makes the divorce irrevocable. So we may say that a talaq in the badai mode becomes irrevocable immediately it is pronounced, irrespective of Iddah. So writing of talaq-nama is not necessary for this talaq even. So it is only the intention of the maker which is to be seen from the words of mouth which he utters. Whatsoever he utters, this will give the consequence of divorce. So his intention is to be gathered from that. Sometimes it happens that a man gives the power of divorce to others. That is called delegation of power. Talaq-e-tafweez. Talaq-e-tafweez is a recognized mode under Hanfi law of divorce. A man may entrust his powers to any other person, even to the wife herself. The husband may, in person, allows his wife, or he may delegate this power to repudiate the marriage to a third person. So this power may be given even to his wife. Such a delegation is called talaq-e-tafweez. So he himself does not divorce the wife, but he gives the power to the wife to divorce it. If you see a nikah-nama in Pakistan, you will find that there is a column in that nikah-nama wherein it is written whether or not you are delegating the powers of divorce to wife. So this type of divorce is also recognized in nikah-nama, which has been prepared under West Pakistan Family Laws Ordinance 1961. So talaq-e-tafweez is a mode under Islam Hanfi law of divorce, which allows a husband to delegate his powers to his wife or to any person to repudiate the marriage. So when a man has said to himself, to his wife, repudiate itself, you may repudiate it. She can repudiate herself at any meeting. Once the husband gives her the powers, when the husband delegates the powers of divorce to her, she may, in a meeting, pronounce the divorce. So that is as valid a divorce as the husband has given her. So this type of divorce is not usually seen in our society, but recognized by our law. So this talaq is recognized under Islamic law. So this is called talaq-e-tafweez. Next time we will study the judicial divorce.